Greetings. This is Attorney Della Welch, and this is tape 2 on the subject of preparing your family law case for trial. This is intended not to replace legal advice, but to help you in talking to your attorney and evaluating the issues. We were talking at the end of last tape about waiving the court reporter fees, and there is a form. Take the original to the court, keep a copy for yourself, and there is a form that you submit with your final trial binder, and that will be asking the court to waive the court reporter fees. The court should let you know within about a few days, and they will let you know if they will waive the fees, or if they don't waive the fee, the time period in which you have to post the fee to keep your trial date. So you have to watch your mail for that. Now, in speaking more about the trial binder, when you file that, remember to have the various sections such as the index to your binder, the disputed and undisputed issues, your trial brief, your witness statements, and then information about the financial assets and the information on the debts. And then one thing you'll need to do is do a proposed order, how you want the case to come out. You actually prepare the order, and the other side prepares the order, and the judge looks at that and decides on the final order. Remember, the petitioner, the one who files the divorce, has the burden of proof, and also they go first in the level of questioning. So the petitioner goes first, and if there's any exhibits that need to be used, they need to be laid with the proper foundation and introduced into evidence. And then the cross-examination of the petitioner occurs by the other side. And then the petitioner calls the various witnesses, and each witness is cross-examined by the other side. And after that, the petitioner rests. Before you rest, make sure that you have addressed all the exhibits that they can come into evidence, and then you can rest. Then the respondent has their part. What happens is the respondent is called and cross-examined, and if there are any witnesses that the respondent wants to call, each is called one by one and cross-examined, and then the respondent rests. Then each party has a closing statement. The petitioner makes their closing statement and says what they want the court to order, and be very specific in terms of how much spousal support you want, how the debt you want to be divided. Go through each issue, summarize factually what occurred first, and then go to what you want the court to order. Then the respondent does their closing argument. Then the judge will either decide on the record and give the decision, or often the judges take it under submission and think it over and let you know in a few days, and you receive the order by mail. The final order is very important and must be served on the company with the 401k plans, if you have that. If there's a pension, there's a quadro QDRO that you must be concerned about. So this has been a summary of what goes on. You'll be surprised just how large a hard drive or a 3-ring binder is when you prepare all this information. I say start early, do a little every day. And what has happened in California, the attorney fees are very high, $450, $500 an hour. So if you're in court, your trial may take 2 days. You need to give a trial estimate, 3 days or 4 days. And if you're paying $500 an hour, it's very expensive to go to trial. I advise clients, if they can settle, they may be able to save some money. But in the 1980s and 1990s, attorney fees were not that high. The courts were not as busy, and it wasn't as congested. And now it's much more difficult to get a dissolution of marriage. So I hope that this has been helpful to you and given you a lot of ideas, and the ideas will help you